The first will speak is Manoj. Manoj Dias-Abey is a lecturer in law in the University of Bristol, the UK, and he's interested in the strategies employed by non-traditional labor organizations in North America and the UK to present migrant workers, and he's also researching the law and political economy of temporary migrant labor programs. Manoj, please. Yes.
Yeah. Thank you.
Good morning, everyone. It's a great pleasure to be here and speaking alongside these fabulous speakers on the issue of migrant worker solidarity. So for scholars of migration, it's difficult not to be depressed by the extent of anti-migrant animus infecting our political and political culture right now. So, but perhaps this is an unduly pessimistic appraisal of the current political moment, especially when we examine the labor activism that's taking place in the United States and United Kingdom. Looking around at labor struggles in these post-industrial countries today, it's hard not to be struck by the extent to which migrants seem to be front and center of these movements. You can hear me? Yeah, great. Whether it be Somalian workers in Minnesota who have organized against work intensification at Amazon's notorious fulfillment centers, or undocumented Mexican farm workers in Florida who have leveraged the power of lead firms in supply chains to win new labor rights, or the Brazilian Deliveroo drivers in London who managed to catch off guard the company's executives in 2016, it's hard not to conclude that a multiracial and multi-ethnic labor movement is on the march on both sides of the Atlantic. In fact, rather than hampering resistance, solidarities based on racial and ethnic identities seem to be a fulcrum of rank-and-file struggle today. And to some extent, this has always been the case, although in the popular imagination, this fact tends to get lost. So this simple observation about the diverse nature of modern labor movements has prompted me to start thinking about the entanglements of migrant status, solidarity, and the law. So to understand the connections between these three concepts, we have to think carefully about the relationship between legal categories and social categories in the workplace, and how these interact to inhibit or promote labor organizing. Of course, in reality, it's not very easy to disaggregate the legal from the social. Most concepts such as citizen have both legal and social dimensions. However, for analytical purposes, I think, it's useful to distinguish between the legal and social aspects of particular concepts and see how they interrelate. Now, as a legal scholar, it pains me to say this, but in analyzing the relationship between the social and the legal, it's important not to overvalue the work that law does. As Liam McHugh Russell has argued, just because many categories of social life are also legal concepts, it does not follow that these categories are entirely legal. Many obviously legal categories in the workplace, such as employee, independent contractor, illegal worker, have social foundations and social consequences. When we talk of certain categories, such as citizen, we need to recognize that they have also been constituted through processes such as state formation, racism, colonization, and globalization. So to ground my inquiry into the relationship between the legal and social categories in the workplace, at least for the purposes of this paper, I'm going to focus on three sites of study in the United States and the UK, and they're up there right now. So farm worker struggles in the US, driver mobilizations in San Francisco, and Deliveroo rider mobilizations in the UK. So I'm going to spend some of my time today setting out the broad contours of a research project that I've only begun fairly recently, and it's quite a bit of a shift for me because thus far in my research I've sort of looked at the meso level. So I've been focusing much more on labor organizations that represent migrant workers, and now I'm shifting more onto kind of looking at what the psychological processes that workers go through during the process of labor organizing. So given what I've said about the objectives of my research project being to consider the relationship between legal and social categories in the context of labor organizing, I want to outline two main research questions. Number one, what are the social effects of legal categories such as employee, independent contractor, and illegal? And how are cultures of solidarity, which are capable of overcoming legal and social divisions, formed during the process of struggle? So I'll try and elaborate on this with reference to some example from those sites of study. And towards the end, I'll try and offer some broader reflections about the relationship between broader labor movements, solidarity, and the law. So we often talk about the constitutive power of law. The point, particularly well articulated by legal critical scholars such as Carl Clare and legal historians, is that the law is not only a tool of domination by the ruling classes, it has a life of its own, helping produce and reproduce the social relations of capitalism. In the workplace, legal categories such as employee, independent contractor, temporary worker, illegal worker constitute subjectivity and influence social relations. I'll call these two interrelated processes the social effects of law. So, but what are the mechanisms through which this occurs? For a start, the law tells us what we should and shouldn't do, that is, how to behave. It ensures compliance with these norms through a sort of a enforcement apparatus. And through instantiation in the law, categories gain legitimacy and stability, and eventually the law starts to shape how people see themselves. So let me provide some concrete examples. Being an employee means being subject to the wishes of the employer. An employer has the right to legally ask an employee to deploy their labor power in a way that suits their own interest, so long as that request is not unlawful or unreasonable. The subjection intrinsic to the legal status of employee also has social foundations. A worker may comply with the orders of an employer for reasons other than fear of just the legal repercussions, for example, social norms of behavior. In contrast, being characterized as an independent contractor may give rise to a different identity and potentially a different set of behaviors. Contractors may see themselves as having flexibility, freedom, and exercising entrepreneurship. I want to bring in an example from one of my sites of studies. Some of you in this room will be familiar with the work of Veena Dubal, who is a labor law scholar in the United States. She's done some amazing ethnographic work on taxi and Uber drivers in San Francisco. One of the insights that she gleaned from my ethnographic study was that drivers derived social meaning from being described as an independent contractor. She found that for the largely immigrant Uber drivers she spent time with, being classified as an independent contractor signified freedom and the ability to attain some measure of social mobility through an entrepreneur identity. These drivers were not convinced of the benefits of an employee identity, with its elegiac promise of a return to a past with better working conditions. Legal categories can not only affect how we see ourselves, but also how we relate to each other. All workplaces contain vertical hierarchies of one sort or the other, the most common being on account of occupational hierarchies. But hiring workers performing the same role under different legal guises can also add to this horizontally. For example, some workers may be hired as employees, others may be as independent contractors, and yet others may be employed through a temporary agency. While all these workers may be engaged performing very similar types of work, these legal differences between workers translate into different positions along a rigid status hierarchy. Citizenship status in particular is a very important legal category that shapes how workers relate to each other. Illegal workers, produced by the intersection of immigration and labor law, create various workplace partitions. Undocumented workers may not see themselves as part of a workforce that can agitate for change. On the other hand, because citizenship confers a series of rights to the local workforce, even if they're quite difficult to realize in practice, these workers may see themselves as part of a privileged category. The law, through differentiated access to a range of social and political rights, creates ideational differences that have very real material impacts in the workplace. So what I've outlined here, I think, is largely an interest-based conceptualization of identity formation. By according different groups of workers different rights and duties, and distributing privileges and restrictions in very specific ways, I have argued that these groups start to develop different interests. Of course, these workers may all have a long-term interest in seeing the transformation of the economic order, but the immediacy of their needs can obfuscate this much bigger point. These legally formed types of identity in the workplace exist alongside social identities, such as ethnicity, gender, and sexuality. Workers with different social identities can understand and articulate their interests in all sorts of complicated ways, as we've seen with the immigrant Uber drivers who profess to prefer a contractor identity. So in the next part of this talk, in the time that I have remaining, I want to think about the intersection in the context of solidarity. So the story I've told so far has largely been one about law forging disparate identities and sowing seeds of division in the workplace. Since the basis of solidarity in the workplace is workers coming together and overcoming differences to present a united front against the employer, this might suggest that the fragmentation of identity caused by a variety of legal categories is anathema to labor organizing. But I think this would be too simplistic a rendition of the role of law in forming and deforming solidarity in contemporary workplaces. I want to argue that legal categories also enable, just as much as they disable, solidaristic action, especially when we consider that legal categories operate in tandem with social differences. Furthermore, I want to point out that through the process of labor struggle, new identities can form, because identity is not fixed or stable, and the law is deeply implicated in this process. So I need to make a small detour first, I think, to clearly define what I mean by solidarity, because it's a concept that's notoriously difficult to get a handle on. Solidarity, for me, is not something that either exists or does not exist. Rather, it's a dynamic, evolving spirit that's produced and expressed through the act of taking collective action. I think that the work of the American sociologist Rick Fantasia offers us a particularly helpful conceptualization of solidarity. According to Fantasia, rather than seeing solidarity as a particular mental state, he argues that we should see it as a set of practices generated in social struggle. He introduces the term cultures of solidarity to describe the cultural expressions that emerge when workers seek mutual aid and confront power. There is no single expression of solidarity. A variety of institutions, practices, and organizational forms can be emblematic. So I think the law can play an important role in facilitating the formation of cultures of solidarity. I want to provide 3 examples from my sites of study to illustrate some of these ways. So so workers who attempt to work without proper authorization can find it really difficult to find work. Often they have to rely on an ethnic compatriot who might be moved to provide them with a job. The gig economy offers workers new possibilities to help their undocumented friends, since the independent contractor status, at least technically, allows the worker to provide a substitute. It's a fairly well-known fact that Brazilian Deliveroo drivers in the UK will loan out their accounts to friends without documentation, sometimes for free and sometimes for a small fee. We can think of this practice of solidarity as being enabled by the legal category of an independent contractor. My next example relates to the Coalition of Immokalee Workers, a farm worker organization based in Florida. One of the great successes of the CIW is the development of a Fair Food Program, a private governance initiative that covers 33,000 tomato harvesters. The Fair Food Program provides farm workers with a suite of labor rights that exceed the minimum standards set out in legislation. So we're talking about rest and shade breaks, fair payment, protection from sexual harassment, and direct employee status. Most importantly, because the Fair Food Program is a system of private governance, it applies equally to workers whether they are documented or not, an important fact on Florida's fields where the vast majority of workers are undocumented. The existence of these private rights provides Florida's farm workers with a psychological ballast, I think, to resist exploitative conditions. Since the Fair Food Program has been in operation, we have seen workers gain the courage to defy crew leaders who are abusive, pursue wage theft claims through the Fair Food Program's enforcement mechanisms, and otherwise challenge bosses who don't comply with the rules. Third, strategic litigation, given the right conditions, can lead to the formation of cultures of solidarity. There is a strong tradition in socio-legal scholarship exploring how court action can cohere movements by helping disparately situated workers develop new identities based on a shared sense of grievance and visions of a better future. In some of my sites of study, I think it's possible to infer that participating in litigation has acted as a cohesive factor which has helped build cultures of solidarity. The employment misclassification litigation that unions like the IWGB have run in the United Kingdom, I think have pushed drivers to see themselves as a cohesive group denied rights available to other workers. More recently, the IDWG has lodged a race discrimination claim against Mayor Sadiq Khan's decision to impose a congestion charge on the mainly immigrant minicab drivers by leaving the mainly white taxi drivers exempt. I think this litigation has the real potential to build solidarity by giving expression to the lived experience of an immigrant workforce. Yeah, I'm wrapping up. This is my last slide. So I've tried to offer a complicated story about how legal and social categories interact in the workplace. My purpose for doing so was to try and problematize the simplistic notion that social diversity in the workplace devastates a pre-lapsarian past where workers stood in solidarity with each other. But how should we understand labor struggle in multiracial and multi-ethnic societies? I think the traditional model is to see labor organizing as bringing about a singular worker identity that's oppositional to the employer. There's a strong element of false consciousness in this conceptualization. Through the act of labor struggle, so this model posits, workers will be able to see past workplace divisions and identify their real foe. So this is a quote from a 1979 film, Norma Ray, that some of you may have seen, one of my favorite films. And there's this very sort of stirring scene where this union organizer tries to unite a white and a black workforce using this particular quote. I'm not going to have time to read it out, but you can read it out yourself. Now, as stirring as this speech is, I don't think that it's particularly helpful because it underplays the extent of legal and social diversity in modern workplaces and what needs to be done to overcome it. Solidarity in the contemporary workplace requires more than an appeal to a transcendent worker identity. It requires finding out how diverse workers articulate their own interests and fighting for claims that advance these. So this is what the scholar Tamara Kay has described as, begin quote, radically confronting colorblindness in our strategic organizing frameworks and ensuring identity consciousness in our conceptualization of justice, end quote. So thank you for listening. I think I'll leave it there.